One defendant accepts a prison sentence without a fight. Another claims a 5-hour energy drink caused a positive meth test, and the judge isn't buying it. Then, a child endangerment case takes an unexpected turn when the judge delays sentencing to learn the full story. Stay until the end to see how each courtroom decision unfolds.
It's okay. All right, sir. I'll recall, obviously, the bond forfeiture. And so, Mr. Van Wright, you were previously in court and entered pleas of true in a motion to revoke your probation and entered plea of guilty in the new offense. Can you send me that paperwork just because this is all... And the agreement was for 2 years TDC, and I gave you a little bit of time to come back and be sentenced today, correct? Were you arrested for anything between that time and now? So if they were agreed, I should have these printed out. We shouldn't have these if they were agreed. There they are. All right, and wait just a second. Sorry, I'm a little out of sorts. What? Take retreat.
There's only one count.
Okay. And then change it. Got it. All right, Mr. Van Wright. In cause number 24 DCCR 2485, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 15-23582, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find sufficient evidence in that case to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive. The cases will run concurrently, which means together at the same time. I'm handing you in each of those cases trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can speak with your attorneys. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Simmons. All right, Mr. Harris, this is 24 DCCR 2254. You tested positive this morning for methamphetamines and amphetamines.
I drank a lot of pop-up powder for 3 days, and that's the only thing I think that was going to pop. I've been used to my kids. I ain't been around here right now. And I drink a lot of pop-up powers already.
5 Hour Powers is not going to test positive for methamphetamine.
If you send it off to the lab, I'm sure you'll see that it's not. I don't do anything like that. I don't have the money for that.
Well, all I know is you tested positive for methamphetamine. And obviously there's some concern because you were arrested while this case was pending, and Mr. Coleman figured that out. Hold on.
So it was a traffic ticket.
Just hold on.
I would just observe this, if it's paraphernalia, that's a class C, and normally those aren't arrestable. I mean, it is an arrestable offense, but normally it's just exhibit. It's a jail on fine.
Doesn't matter. If you're on bond for a felony, you should. I just asked you not to say anything else right now, okay? I'm just checking on something.
Let her check.
Obviously, Google and AI is not the end-all be-all, but it is unlikely to cause a positive result on a standard drug test. A 5-hour energy drink does not contain prohibited substance like THC, opiates, or amphetamines. Extremely rare and undetected issues involving cross-contamination during manufacturing would do it, so I don't think that's what we're worried about today. I'm going to grant the state's motion to raise your bond based on the fact that you tested positive, based on the fact that there was an additional arrest while you were on bond for a felony offense. I'm raising your bond in your case. It's currently set at $30,000. I'm going to raise your bond to $75,000. I'm going to order, as a condition of that bond, that you have a drug patch at all times, that you get it changed out as you're supposed to. Your case is still set for trial to begin with jury selection on Monday, and is everybody ready for that?
Yes, Fred.
All right, I'll number the case. If you're in custody, we'll have you brought over for trial. If you're not, then you can talk to Mr. Kimler this morning, okay? All right, you can go back with the bailiff. Good morning. Just a second, let's see if this is Mr. Hoffpower. And again, you're Diamond Smith. And Mr. Burbank, will your client waive the formal reading of the indictment? Ms. Smith, in cause number 24, DCCR 2056, you're charged with the state jail felony offense of abandoning or endangering a child, and that's from June 14th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablets and documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Burbank? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Ms. Smith is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report. That'll give me more information about you, your case, and then we'll go forward with sentencing at that time. And I know it's a state jail, but I think on these types of cases, I like to get all the information so we have a plan in place.
I think there was a co-defendant.
There was a PSI in that case, Judge. So I'd like to do the same thing as well.
No, I'm going to get I need a PSI with her information in it. Okay, you need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Thank you.
3 defendants. 3 completely different outcomes. From a prison sentence and a revoked probation to a bond increase over a failed drug test, and a child endangerment case put on hold for deeper review, every decision shows how one moment in court can change a life. If you enjoy real courtroom cases with a full legal context and no unnecessary drama, make sure to subscribe, turn on notifications, and don't miss our next courtroom breakdown.